everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. On board today, we are discussing the Supreme Court case from March 5th, 2025, in a 5-4 decision where the Supreme Court decided against Trump in one of the cases. This is the case of USAID funding, $2 billion of federal funding. So stay tuned with us to find out what is this case about, why the Supreme Court, if we know, went against Trump, and what does it mean for the future? Because this is one of the first cases we've had by the Supreme Court in the last number of years where we've gotten a decision against him, and it's a very tight decision. So let's discuss that today. And we're also going to discuss a case that's up on oral argument in front of the Supreme Court with reverse discrimination. So that's what we're going to talk about today, and the illustrious Amy Coney Barrett and what she's doing on the court and why there's been some disappointment in the Republican circles with her decision. So I'm Virginia Tehrani. I'm the CEO of The Law Unscripted that hosts the Legal Weekly Wine. I'm also the attorney owner for Tehrani Law, LLC, because you never need a lawyer till you do. And I am joined by my father, the constitutional law scholar, Dr. John Weil, who's the Dean of the Honors College at Middle Tennessee State University. Welcome back.
Good to be here.
All right. We always have so much to talk about, but this one, I've been the amount of angst and tears and yelling and praying and laughing in the last, how many weeks have we even had Trump as president? 6 weeks, 7 weeks?
Since January 20th.
I tell you, the range of emotions, my husband is really sick of me being in the house, and the random comments I make is, really this now? And what's happening here? And he's like, I don't know if I like that you're an attorney right now. It's like, I don't know that I like that I'm an attorney either, but between me as an attorney and you as a scholar, especially on the Supreme Court, the Constitution and constitutional law, I know you and I are having a rough go of things right now.
We are. You know, there's a fascinating article in The Guardian by a guy named Ed Pilkington, and it's called "Nothing Like This in American History, The Crisis of Trump's Assault on the Rule of Law." And he points out that this is really one of those few times. Now, there were a lot of questions during Nixon's administration, whether when he was ordered to turn over the tapes, whether he had said that he would not, the Supreme Court decision would have to be definitive. And of course it was 8-0, one recusing himself. But when the court said he had to turn over tapes that he had made in the White House, he agreed, as you know, we had discussed earlier. Harry Truman did when he was told that he didn't have the power during the Korean War to seize the steel mills. There seems to be real concern, partly fed by J.D. Vance, vice president, graduate, a Yale Law School graduate, who has sort of added his voice that he's not sure that the president needs to obey the Supreme Court. And of course, if he doesn't, it calls the whole idea of the rule of law into question.
Yes.
Congress is supposed to have the power of the purse, and that's been seriously called into question, partly by this case that we're going to discuss. President has executive power, but the courts have the power of judgment. And as we've discussed before, some people fear this could lead to judicial supremacy, and that's always a concern. It's always possible that courts will overstep their bounds. On the other hand, they have the least incentive to do so. They are insulated purposely from direct politics, and presumably, they are sworn to uphold the Constitution of the United States. And if the court gets it wrong, it can correct itself, as it's sometimes done. Or if you have sufficient majorities, you can adopt a constitutional amendment. So
Congress and the states can take care of it.
That's right. And one advantage or one reason that it's hard to be too concerned about judicial supremacy is courts can't just go out like a president and give a speech and announce a new policy from one day to another. They have to wait till cases come before them. And they
Exactly.
often come sort of in messy fashion. They're not always the
And
way that you
slow.
would want to phrase a particular issue. And so, again, that serves as a kind of restraint, as does the presidential power of appointment and confirmation. Justices don't live forever.
Right.
And the current court has three justices that Trump appointed during his first term. I would say he was lucky, but it was a combination of luck and really shrewd, I think, unethical politics, because they should have had a vote on Merrick Garland before Obama left office, and they
Right.
probably should have waited on Amy Coney Barrett until Biden became president. But neither of those happened. But typically every 2 years or so, there is a vacancy on the court. I would think that the Democrats on the court, or those who lean in that direction, would be inclined to hold on with their fingernails as long as they can.
We're going to
And
stay here
actually, I
as
believe
long as possible.
I believe actually the oldest person on the court is Clarence Thomas,
Yes.
who it'd be very difficult to find someone more conservative or to the right than he is. But these raise significant questions about separation of powers, about what are the limits on presidential powers.
Right. And do check out you're talking about our prior podcast. The one we just did is called "Can the U.S. President Refuse to Follow a Court Order?" We'll drop that down in the links in the description so that you can find that very easily. And that is one of the things we continue to grapple with is, what if he refuses? And I've gotten a question or two from a colleague saying, well, you're just pontificating about what ifs. Why are you talking about what ifs? Well, I believe we're talking about them for two reasons. One is it's not just a what if. And I'll explain more about that in a second. But two, if we don't talk about the what ifs, we're not going to be able to figure out how to handle that situation. It's more a reactive situation. And in my line of work, especially as an attorney, we get better work done, more work done if we're proactive versus reactive. It's more of an emergency fight or flight response if it's reactive versus considering all the possibilities and then what do you do? And in this way, I think a lot of the, whether you like it or not, whether anybody likes it or not, a lot of the states prior to Trump taking term did get together, whether it was the governors or attorneys generals for the state, they did get together and start crafting plans of what if X, Y, and Z happen. And they started drafting briefs and they started drafting motions. And that's what we're seeing with a lot of these lawsuits that are being filed overnight for some of the decisions that have been made and executive orders that have been implemented is a proactive use where people got together and said, what if? And they started to respond prior to it happening. So the other piece of this, and Dr. Weil, I want to make sure that I'm on the right track. The question of what if Trump follows a court order, and this one in particular we're discussing is what I'm talking about, because this case is specifically Department of State versus AIDS Vaccine Advocacy Coalition. And it's a question of what to do with this $2 billion aid package for USAID that was granted by Congress, approved by Congress, already allocated, and according to this opinion, was actually already worked for. And I know I just used a preposition at the end of a sentence, so I got to pause there for my grammar person here.
I have got to leave this program. It's clearly not sophisticated enough.
It's gone downhill. So the work has already been completed, but the funds are being withheld. And ultimately, it's here because when the case came before the district court, the United States District Court for D.C., the District of Columbia, the court ordered Trump to pay the money. Right. It said, you know what? You have withheld the money inappropriately. we believe you must pay it. We can come back and fight the merits of the case, but you must pay the money in the meantime. And we're here because he's refused to do so. So in my mind, we're not playing the what if game. We're playing the it happened game, where he said, I'm not going to obey this district court judge who said I have to pay the money. I'm not going to pay the money. So he's gone
four
up.
People,
yeah, go ahead.
People on the court actually side with the government. They say, and here we get to this earlier discussion, they say this is judicial overreach.
Right.
A district court, which is the lowest in the federal court system, single judge should not be making this decision. On the other hand, I guess what the court and what's bizarre about this is we basically have an unsigned. Robert says, well, that's worth discussing. He issued a stay on the order. The full court looked at it, and apparently 5-4,
right,
by being unsigned, say, no, the money's been appropriated. Congress has the power of purse. They have to appropriate it. But 4 justices say, no, this is judicial overreach, partly because, this is a district judge doing it. And you mentioned, and I'm not sure, well, I'm sure that Trump had some legal defeats in his first term, but this may be the first sort of defeat by the U.S. Supreme Court, but he's lost all kinds of cases at the lower court level.
Right.
And I think the conservative justices are a little afraid that maybe they're concerned about their own power. That we have perhaps they think some rogue district judges here that are going a little too far. One of the district judges openly said, we don't have a king here. And some people consider that provocative. I don't consider it particularly provocative, since we're going to be celebrating 250 years next year of not having a king.
Right.
But I can see how it might be taken that way. And, one of the fascinating things about this and a few other cases is Amy Coney Barrett was apparently in the majority.
Right. She was number 5.
Right. And she's the appointment that was squeezed through right at the end of the Trump administration, even though they had refused to do this for the Obama administration that preceded it. And this is good. And I mean, Supreme Court justices are not there to be yes men or yes women,
right?
Because they're appointed by, and presidents for centuries have bemoaned the people that they appointed to the Supreme Court.
They've always, a lot of them have come back to bite them. Yes.
Right. Now, not always. John Adams said that his appointment of Chief Justice Marshall was the most consequential, best thing that he did. Eisenhower was once asked, had he made any mistakes when he was president? He said, yes, 2. They're both on the Supreme Court. Theodore Roosevelt once said that he could, and I believe it was Oliver Wendell Holmes, who was hardly a wilting flower, he said that he could carve a better spine out of a banana than he could with Chief Justice or Justice Holmes. But of course, we want independence. We have 3 coordinate independent branches,
right?
And the power of the job of the court is not to affirm or deny something just because the president did it. Right. It's to look at the Constitution. The Constitution very clearly gives the power of the purse to the president.
To the Congress.
Related to
Congress.
This, I'm sorry, to Congress. Yeah, okay.
Careful.
Okay, I better be careful. Yeah, okay. We're going to set constitutional law back a couple generations here.
I'm a mere lawyer. You're the Constitution expert.
Okay, well, you caught me on that one. But power of the purse belongs to Congress. And, the other power that belongs to part of Congress, which is the Senate, is the Constitution requires that all principal officers of the United States, typically cabinet officers and above, they are appointed by the president with the advice and consent of the Senate. And we've been through
confirmation.
2 months of hearings.
How many different
people? Several that were confirmed, I think, are utterly unqualified or certainly not up to the snuff that they ought to be.
But they
they've
went
been
through the
legally confirmed.
process. Exactly.
Elon Musk is exercising apparently more power than any of them, and his name has not been confirmed.
It was never confirmed. And I think it's Trump has gotten around it by saying he's not a cabinet position. But the thing is, he's overseeing essentially the cabinet. We've seen multiple meetings where he came in and ran one of the meetings. So he's acting in a cabinet position.
Go back to this USAID case. It's one thing to talk abstract policy.
Right.
We're going to cut government spending. I find few people who are opposed to, in theory, and particularly if it's fraud, waste, and abuse.
Absolutely.
But simply calling things fraud, waste, and abuse and firing people who are probationary or firing veterans just because you're trying to meet a quota, or somebody who's unappointed tells you that they should, unconfirmed tells you that you should do so, means that lives are being hurt. In this case, we're talking about one of the most successful public health programs that the United States has ever engaged in.
Yeah.
Just a generation ago, we were talking about a whole millions, literally, of people in Africa that were orphaned because their parents had both died of AIDS.
Right.
And now we have, gotten a medical protocol that can save lives. And certainly that must build some goodwill. I mean, first, it's the right thing to do.
Sure.
But you would think that something like this would build some goodwill for the United States.
Well, but that's what you were talking about in our other podcast, is this soft power.
Absolutely.
That it is a soft power, and the fear is of what's happening with China is that China's coming in to replace us with that soft power of building bridges. What's the actual program? You remember the name?
Yeah, the Belts and Roads or some such.
Right, where they're coming in and restabilizing community, building their bridges, building their foundations, so that when those communities look, they say, "Oh, China's given us aid," and that's right. Part of the purpose is to help humans, right? To help human suffering.
Well, and again, you touched on another issue, which is, government needs to fulfill its contracts.
Right.
I spend, would that I had it, but if I were spending $1 million on behalf of the government on the basis of a promise, and the government didn't come through with it, right. I would be hurt as an individual.
Absolutely.
And individuals, the reason that courts don't generally, they don't pontificate on general matters. They look at specific cases. Right. Here are people that have spent money.
Yes.
On behalf of the government, it would be like
based on a contract.
Right. If you had entered into a contract to prosecute someone with the government and you did your job and then they wouldn't pay you for expenses, that's not fair to you.
Exactly. And that's where it comes back to basic law, not even constitutional law, basic law of contracts. Right. Is just like you're saying, if you enter into a contract, this is a basic breach of contract case when it comes down to it, where these agencies say, the government promised me, forget Congress, the government, right? The government promised me, I entered into an actual written contract with them. I performed my duty. They did not fulfill and pay what they owe me. That is a basic breach of contract. And depending on how the contract is written, I don't do government contracts. I haven't seen these contracts, but some contracts in general are written with provisions of, if the contract is breached, then interest is owed on any amounts. Attorney's fees would be owed to the prevailing party. There's pre and post judgment interest. There's costs and expenses that are added on, where in the end, the government might want to look at this and say, okay, wait, which contracts did we actually breach? Allegedly. And what do those contracts say? Because in the end, they could well be liable for much more than $2 billion that they've already allocated. So we've got the congressional issue of, what did Congress allocate? Then we've got the contractual issue of what did we promise to pay, what didn't we pay, and what's the cost of not paying it. Can we just void out these contracts, and what happens if we do? So in the district court level, what we've got, and this is going to go towards the dissent here, the district court is looking at a case where all of these contractors say, you know what, we had a contract with the government. The government's breached their contract, refusing to pay $2 billion. Now, we take out the word government. Just take it out and say, you know, this company, we'll call it a company. This company has a contract with us to pay $2 billion and they haven't paid us. A regular district court judge, federal or local, would look at that and say, wow, that is a potential breach of contract. We are going to order you to pay it in the meantime while we sort it out. And what's that?
Sovereign immunity.
And that's where we get to the dissent.
That you can't sue the government without its consent. Now, it can give assent through legislation. So that's one problem. The other, which most people don't know, so there's a contract clause in the Constitution, but it's limited.
Yeah.
It says no state can abridge contract rights. It doesn't apply to the national government.
Right. It doesn't say federal government, just states.
Right. And there's a reason for this. It goes back to James Madison, actually, in factions. He thought that at the state level, it would be particularly likely that factions would take over and do injustice. And he thought at the national level, that would be far less likely. I'm not sure that turns out to be the case in this instance. So it is complicated by these factors, and I don't specifically know how they come into play here. But you know, good for Amy Coney Barrett or anyone who shows a little independence. Either way, if you know, there's a partisan dimension to Supreme Court appointment and confirmation. But there's also an important legal, you know, I don't want to think when I go to a court that it's going to rule for or against me on the basis of what party I identify with.
Right.
To end with to end with the preposition.
Right. I mean, you're getting stuck in it too. This is how upsetting this is.
Yeah. Okay.
Well, in my eyes, the Supreme Court, the judges are supposed to be more neutral. Now, in reality, it's hard for anybody to be neutral. Judge, prosecutor, defense, whoever it is, whatever they are, there's always an issue with neutrality. But judges are supposed to be more neutral than a congressperson or the president who have a party affiliation. Now, unfortunately, the party affiliation nominates the Supreme Court justice or nominates the federal judges.
And confirms.
Exactly, gets them confirmed based on the Senate, and that's Republican now too. So we do have a somewhat non-neutral, but in the end, it's based on the law. And in my mind, this is really hard. I know that 4 people are saying, and the question that the dissenters get into, and this is very interesting to me, is the dissent is narrowing in on a question of, quote, does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? That's the question that they have there.
Right.
They say the question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. The hard part is I am stunned about this defense, because what it seems to be saying is the district court has no legality at all, that they have no authority to do anything. So if the district court can't do it, who can?
What they're ignoring is that a majority of the court has reviewed that decision and decided that given the reasoning of that decision, it is valid. So it's not one court making the decision. It's one court and 5 justices of the U.S. Supreme Court that the minority are objecting to.
Yeah.
Now, should they have given, I mean, you could say, should they have given a full hearing? Should they have heard the case themselves? I suppose. But my suspicion is that you probably would have ended up with the same 5-4 majority.
Right. So this sovereign immunity piece, you were discussing that. What does it mean for sovereign immunity? As I understand it, and the court is actually quoting, it bars, quote, a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury.
Right.
Now, in my mind, then, if that's true, and I know that it's in the Constitution that they do have sovereign immunity, the government has sovereign immunity, but how then does anybody enforce a contract with the federal government? And if that's the way that it's being read, why would anyone enter into a contract with the federal government now that could just be poof and it's gone because we're immune?
And it's not just the federal government. States is the sovereign immunity. I believe it's state level too. Chisholm versus Georgia, you'll remember from constitutional law.
Oh, sure.
Was like an early case in which Georgia was refusing to pay debts that it owed that it had borrowed to fight the Revolutionary War, and the Supreme Court, I think, correctly read the Constitution and said there's no sovereign immunity listed in the Constitution. They have to pay. And there was such an outcry that the 11th Amendment was adopted, first such amendment after the Bill of Rights, saying, in fact, that states did, you could not sue a state or federal government without its consent. Consent can be given in a number of ways. If the state initiates a suit, then you clearly have a right to, and there are laws, when the state enters into contracts, there are laws governing whether the suits can be raised or not. So people do have some forewarning as to whether sovereign immunity will be invoked or not.
Yeah. The dissent is also discussing it's where are they even going to come up with $2 billion? Well, allegedly, they already have it if it's already been allocated and appropriated.
Right.
So if we didn't have it, we shouldn't have allocated it or spent it in the first place. So it's hard. This one is really hard for me. Well,
it goes to a larger issue, which is basically Trump administration is alleging that it has the power to dismantle an entire federal agency, all of which has been created by and appropriated for by the Congress.
Yeah.
And I think it's, and we're getting there's a similar issue being raised right now about the Department of Education. Now, part of it, frankly, seems to be a parlor trick. People who say that they're going to dismantle the Department of Education, if you say, does that mean Pell Grants? Oh, no, we're going to move that over here. Does that mean this? No, that we're going to move it over there. So it's, in some ways, it's, find where the P is. You can't find it, so it's no longer there.
Right.
But I think there's serious questions as to whether the president has this kind of power. And of course, the other area where we're going to get to this is the president seems to think that he has the power to fire heads of independent regulatory agencies. And I don't know if we've talked about Meyer versus United States and Humphrey's Executor.
We have not.
But Myers versus United States, 1920s, by Chief Justice Taft, was a decision involving whether President Wilson had the power to fire a first-class postmaster. And the argument was that under the Constitution, federal officers are appointed by the president with the advice and consent of the Senate. So for the president to be able to fire them, he also needs the advice of the Senate, which he didn't have. And the court, I think, rightly said, no, when it comes to purely executive agencies, the president is responsible for enforcing the law. If the president knows something that he doesn't want to share with Congress, or somebody's just doing an inefficient job, he ought to be able to fire them. And that's the leading case in this area. Then in the 50s, Humphrey, I believe it was the 50s. The case Humphrey's executor comes up, and the president has fired someone who's head of an independent regulatory agency. And these are tricky because, going all the way back to the Interstate Commerce Commissions in the 1880s, and we have a whole alphabet of, federal agencies that
Right.
are not completely executive in nature and sometimes are partly judicial in nature.
Correct.
And the court has said in Humphrey's executor, it basically made a distinction between purely executive officers and these heads of independent commissions. There are a number of people on the Supreme Court, mostly on the right, who are sort of itching to overturn that precedent and to give the power of the president, give the president the power to fire heads of all these independent agencies. They need to be careful what they wish for, because it's going to work both ways. If Republicans can fire them when they come in, then Democrats can fire them when they come in. And particularly when it comes to things like the head of the Federal Reserve Board, we're seeing this right now. Whether you favor Trump or not, does anyone favor government that jolts back and forth every other day? Right. Or do you want some kind of continuity?
Or even if not every other day, at least every 4 years or every 80 years.
Right. And this, I don't know if we've talked about this before, but, one of the benefits of the separation of power system that we have is that you get a new administration and you bring about certain changes, but you don't jolt, in parliamentary systems, you get the labor government in, they start nationalizing property, and then the conservatives come in, they sell it off back and forth. And our system has had much greater continuity, but we're not getting that kind of continuity with the Trump administration. And to some extent, this is not completely new. I think Biden and Obama abused executive orders.
Yes.
I think that they've gone way beyond what they were originally intended to do. And I think it's a very negative development.
I fully agree with that. I think it's been extremely overused, and even before Obama, but at least beginning with Obama, where that's become the main form of legislation. And I don't think it was ever intended to be the legislation.
And part of it is Congress hasn't stepped up to the plate.
Exactly.
Congress, political parties are useful in, bringing people together, but when they all become yes men and Congress isn't willing to assert its own institutional authority, we're in for a rough ride.
Right. So with that, I know there was one other Supreme Court case that we definitely wanted to discuss, and this is one that it hasn't been decided yet, but there were oral arguments. And Dr. Weil, this is, I believe, an Ohio case. Is that right?
It is. There's a woman by the name of Marlene Ames who works for the Ohio Department of Youth. I may not have that name exactly right, but I think that's Department of Youth Services. And it's very fascinating. She alleges she's been there quite a while. She's gotten good reviews. Her supervisor comes in and, according to her, promotes her supervisor, who I'm guessing is gay. I don't know that. I don't know if the court said this, but she believes she was passed over in order to hire somebody who was gay, who was less qualified than she was. The problem is that under traditional law, you don't, now, a woman you might think of being, women have certainly been discriminated against, but you don't typically think of a white, a white straight person being discriminated against because of their sexual orientation.
Right.
And this gets to the court, and the court says, if you can't discriminate on the basis of sexual discrimination, her case ought to go for, the standard ought to be the same for her as if she were gay and she were saying, I got passed over by a straight woman, or Yeah.
in favor of a straight
simply
woman.
because of that, right. So, and the court it looks like the court is going to agree here that whether you're discriminated because you're straight or whether you're discriminated against because you're gay or
If
trans or
it's sexual
whatever, the
preference
same
in
rules
any
should
way,
apply.
right?
And this is a very, very bizarre case. So they ask essentially the lower court applied the existing standard, says, well, she's not in any prescribed
Protected.
category, so she's going to, before we can accept this case, she would have to show a long pattern of discrimination, which is almost impossible to prove.
Right.
And the court says, you agree with that? And they said, well, we don't really agree with the way the court worded it. And it's like, well, if you don't agree with the way the court worded, and
Why are
here's
you
one,
arguing it?
right? And this is sort of fascinating. You have Justice Kagan, who says, this is what the court said. I don't know exactly what to make of it. You have, someone regarded as a liberal on the court who's saying, this isn't this is an indefensible way to defend a case.
Right.
That's what justices should do. If something is silly, they ought to point out that it's silly,
Absolutely.
whether it's from the right or the left.
Yeah, whichever side it is.
Exactly.
Yeah. No, and that's interesting because one of the other things that my husband and I have been talking about is, well, there are only two sides, and it's like, well, there aren't. I think there are a lot more than two sides. There are definitely two sides legally. There's always a plaintiff and a defendant, or a claimant and a respondent, petitioner and respondent. But there are a lot more middle grounds than we believe. Now, as an attorney, I am used to going and being on one side or the other. I don't sit in an in-between table, in between the plaintiff and defendant. I am the plaintiff's side most likely in my practice, but I do some defense work as well, depending on the type of case. But I think we've gotten, especially as a country right now, where there is only there's two sides, one of two sides, and you have to agree with one or the other. And one of the things I appreciate, especially from college and law school, is that we were able to take even just one case and argue both sides. So that we could look at the other side's argument, look at their opinion, and say, okay, if there's a case in controversy, there's a reason, because it can legitimately be seen on one side or the other. Now, unfortunately, yeah, please go ahead.
Let me mention a book that I've just read.
Yes.
Cross Purposes.
Oh, interesting. That's a pretty
it's
cover.
A book by Jonathan Rauch.
Okay.
And it's very interesting. He is a gay, let's see, what's the other? Okay, atheist, something else. What was
you told me yesterday and I can't even remember. There were three different things.
Anyway, he's someone who believes that virtues that are promoted by religion are important for the support of democracy. And one of the things he argues is that there are times where people on opposite sides can compromise. And he gives an example, and I'm not real familiar with it, but apparently in Utah, there was a law that was adopted that essentially says we will recognize gay marriage, but we think there are certain circumstances, like the cake cases that we may or may not have discussed, where if a cake decorator decides that they do not, it's against their conscience to promote a gay marriage, then you would not force them to do so. And he uses this as an example of how you can, how you can compromise on these issues. And not everybody gets everything that they want, but for the most part, and this would be particularly true in cases, let's say in cake decorating, where presumably there's more than one person who can decorate a cake.
Of course.
So it's a very fascinating argument, and
well, in that sense, compromise has become a dirty word in our current political system. Whereas if we look at the legal system that we have, compromise makes up almost all of my casework. Whatever it is, whether you're doing a criminal case, how many plea deals are made, that's a compromise. We could charge you with this and convict you of that, this many years, or we can compromise. You can agree to plead to this and get this many years. That's a compromise. That's
Well, and
not
even
a bad
more so
thing.
on damages cases, right?
Exactly.
Few plaintiffs are going to get everything that they want.
Defendants aren't either. So I do mostly personal injury work now. And almost, 90-something% of my cases are compromise, where I don't take them to trial and one wins and one loses. No, we settle. We negotiate of, okay, well, I won't take this much in damages. I'll only take this much. I'll give you this much instead of this much. And it's a compromise between the two sides as to what are each willing to accept in the end. And mediation. We do mediation so much, and this is so relied upon in court cases, where almost all of my plaintiff's injury cases, if they're in the circuit court, we end up at mediation. I had a mediation recently on a wrongful death case. The purpose of it is, in the end, instead of risking trial, where only one party wins and the other loses terribly, well, let's decide that we're both going to lose. But in a portion, in a place where we say, okay, well,
we're both going to win.
Exactly.
Right?
So instead of, and I'm making up numbers here, I'm not going to use the actual numbers we had, but let's say it's a $5 million case, and we say, okay, well, I could get $5 million or I could get zero, depending on how this goes. And the defense says, well, I can win it all and pay nothing, or I could pay $5 million. So neither party looks at that as a good thing if they lose. So the risk of losing for either side draws them to the table to say, okay, we're not going to give up the $5 million, and we're not going to take zero. So what in this number can we agree upon that the defense will give and the plaintiff will take? And that's a normal process for all of legal work. Divorces, everything goes to mediation. There are some that go to trial, but divorces chronically and classically go to mediation. I'll give you this if you give me that.
Yeah.
There
I get the kids, you get the dog.
Right.
Or vice versa.
As long as I'm the dog side, I'm okay. I mean...
Okay, not a good example.
Yeah, so to me it's hard looking, especially from the legal system and the courts and Congress. Is negotiation shouldn't be a dirty word. It's something we do every day.
This is why this whole douche thing is such a disaster in my view. I would hate for somebody to, in academia, we've sat through many meetings where we say, if we need a 10% cut, you don't cut equally 10% everywhere.
Right.
Because there's some places where you can cut 20% and do no harm. And there are others where if you cut 2%, you're gonna be losing students, or you're gonna create harm. And as bad as Congress, as much as we like to criticize, and with all the problems that it has, these agencies are created through and rule through negotiation.
Right.
And an outsider coming in with very little knowledge of how government works.
And what those specific positions provide.
Right. And, again, people are being fired. They're veterans. They're people who are starting out in life thinking, hey, I'm gonna devote my life to government service. It may not pay as well, but I really believe in the government.
Right.
And you're kicked in the teeth after a year and a half and fired. What is that going to do for future staffing of the government?
Right. Or the whole debacle with the nuclear agency is, oops, we fired all these nuclear people that we needed.
I have similar fears with NOAA. We don't need all these weather forecasters. No, you don't until a hurricane comes, or
the tornado
there's an earthquake about to happen, or God forbid a volcano.
Right.
These are tasks that we often take for granted, and probably shouldn't.
It's hard. It's concerning times for everyone, and I certainly do understand the other side of wanting to eliminate waste, fraud, deceit, etc. Absolutely, I want that too. Absolutely want it, but the question is, how do we achieve it? And I think that the process is the question.
We've left out a major issue, I'm assuming we're going to cover the Great Chickasaw leg lamp statue case
Oh
or
my goodness, we should
controversy.
have started with the leg lamp
Okay, are
case.
you
Yes.
familiar? Okay, so this is a case that comes out of Chickasaw, Oklahoma, where the town has apparently become something of a tourist attraction by erecting a 50-foot tall statue of the notorious leg lamp from Christmas Story.
Which you love, by the way, The Christmas Story. That is one of your favorite
I
movies.
do. I mean, my only concern is I think the focus on Christmas probably ought to be on a boy other than someone getting a BB gun, but nonetheless.
A little boy named Jesus.
Yes. But that aside, they apparently I don't know if you can see, you probably can't see it here, but if you'll see it's on a nice.
Yeah, no, you've done well there. Okay.
Yeah, it's on the base that says Fragile. Or I believe I'm pronouncing that right from the.
Yes, the way they pronounce fragile on the movie. That's so funny.
Anyway, apparently the producers of that movie are expressing concern that this is a trademark violation, that they didn't have their permission to do it. Now, they do, as I understand it, they have a gift shop there where they do, in fact, sell
Merch.
memorabilia related to this movie. But there's some question as to whether they're going to have to take it down or pay some kind of royalty for, using what seems to be sort of a distinctive trademark. Seems to me that this is a case where the movie would actually benefit from having this in the town. But I have been told, one of my coworkers told me that daycare centers, if they use any likenesses from Disney,
yes,
they're told either to take it down or to pay a fee for it.
Yes.
So that's, the trademarks. Well, are trademarks in the Constitution? Copyrights are in the Constitution. I don't know that the term trademark is in the Constitution, but clearly
it's a similar effect.
Pardon?
It's a similar effect to a copyright.
It is, right.
Yeah.
But anyway, it's
Disney's
fairly fascinating case.
It is a fascinating case. Do we know how it's ruled? Or just that it's there?
I'm not sure at this point, actually, when I say case, I should probably say something other than that. I'm not sure that it's actually gotten to court yet. But apparently the company that owns the rights to the movie is asking them to take it down or telling them that they're going to order them to take it down. And so it will probably get to court.
Yeah. Yeah, I think it will. And honestly, I mean, the whole Disney thing, they're absolutely right. Disney is very proactive in pursuing people who use their images without paying for them.
Right.
This even happens with bakeries who do cakes, etc., and sell their products with Disney images. They cannot do so, and they will be fined or taken to court if they do so without permission because they're for sale. A couple of local bakers, like if you do it without, if I make one for my kid, right? If I love baking cakes and cupcakes. If I make one Disney related for my kid, I can do that. But if I start selling them in the neighborhood, then that's a different issue.
Profit making.
Exactly. Yeah. So it's a question of, would I be making a profit on somebody else's image? And copyright, and in this case, it's a trademark of the movie. And I guess you could say, that the town is making some kind of, potentially making some kind of profit
quite a tourist
of it.
attraction. They're
In my mind, I don't know. I think the other piece would be, instead of the movie, the company, whoever it is, claiming they should take it down, I'd sooner say, you know what, keep it up, but pay us X, Y, and Z
and that
from
may
the
be,
profits you're making.
That would be the compromise kind of thing that we've talked about.
There we go. See, thinking outside the box. And that's the mediation. I love mediation.
Outside the lampshade, right?
Outside that lampshade. Thinking outside that lampshade. Yeah, and why else do we train as mediators and do mediation? And I love mediation. I've got an uncle who does mediation full time and fully respect what they do. And honestly, I think we just need to send a whole bunch of mediators into Congress and into the court for the judges and the politicians is send some mediators in. That's what we need the most. America, send in the mediators. Forget
And
the
by the
clowns.
way,
We already have them.
it did come to me.
Oh,
This
no.
person is a Jewish atheist homosexual.
Oh, okay. That's what it is.
Who is nonetheless very sympathetic to what he considers the virtue enhancing qualities of Christianity and other religions as well.
Nice. All right. So on that note, I guess we're going to wrap up today's episode regarding the Supreme Court's recent decision of Department of State versus AIDS Vaccine Advocacy Coalition, which did a 5-4 decision against Trump, saying that the federal district court could order the government to pay $2 billion in federal relief to the USAID program. So catch our other episodes. We've talked about several others that we've had, including the episode, Can the U.S. President Refuse to Follow a Court Order? Another similar one that we had before that, which also relates to this podcast, is the one called, Is the Dismantling of USAID by Executive Order Legal? So catch those two. Go back and listen to those two. Stay tuned and up to date with us. You can check us out on www.thelawunscripted.com. On that website, we will have access and links to our YouTube and audio podcast programs. We also have some bar prep material, as well as the 8 core classes in law school. If you want to catch up on those, if you want to get help with your studies and doing that, we have those programs for sale, as well as some fun merch. So even if you're not in law school, even if you aren't, don't want to listen to all the podcasts, check out our merch. We've got some funny legal sayings. Everybody could use a good laugh now. We've got them on t-shirts. We've got them on coffee mugs and tumblers. Check those out, and we will catch you next time on the Legal Weekly Wine.